All right, good afternoon, everyone, and welcome to our first In the Boardroom with Andy Phillips and Attolles Law for 2026. My name is Sarah Diedrich Kasdorf. I'm the Director of Outreach and Member Engagement at the Wisconsin Counties Association. And Andy, I will tell you, this is hard to believe, but I have had the pleasure of hosting these now for 3 years. This is the start of year four for In the Boardroom. I
This
cannot
is year
believe
four?
this
That
is
I didn't
year
realize
four. I looked
that's like
back
a
today.
milestone or something. That's really cool. That's kind of like a milestone. We should have cake. We don't
We
have
should
cake,
have
do we?
cake.
We should have cake. We don't have it.
We could have, maybe I can try to find some virtual cake for us by the time we're
Let's
done
do
today.
that. Yes,
But I
we've
was,
got a solid 80 people that want cake and we don't have it.
that's right. I was looking back today and we started this in 2023. So this is the start of year four. Congrats, Andy, for sticking with this for 4 years. I think over
Hey,
the 4 years, we've built quite the library of educational materials and topics that can be found on our website at wicounties.org. So thanks to you and your staff for your continued continued willingness to do this for us on a monthly basis. I have to say I think it's one of the best things we've done.
well,
So,
it's always a pleasure to get on and talk to people about current issues and questions confronting counties. And so thank you, Sarah and WCA for putting this on because it's a great opportunity to connect with a lot of people out there. Otherwise, we wouldn't have that ability to connect with them.
all right. So I think I'm still seeing people populate into the webinar, but we will get started today. Our webinar topic today is county board rules. It is a topic that, is near and dear to my heart, as I think it is to Andy's. And every 2 years, we spend a lot of time working with county officials in reviewing and updating county board rules. Before I turn it over to Andy to get the program started, I just want to make a few housekeeping notes. First, if you have questions throughout this webinar, we are utilizing both the chat and the Q&A feature in Zoom, which can be found on the bottom of your Zoom screen. So if you have a question or a comment, just click either chat or Q&A, and I will be monitoring them along with Andy throughout the presentation. Second thing I want to mention is we are recording this webinar. The webinar recording, along with a copy of the County Board Rules template that we will be discussing today, will be placed on the WCA website shortly following the presentation. So again, you will find the materials on our website at wicounties.org later on today or at the latest, I'm guessing sometime tomorrow. And again, questions, Q&A or chat, feel free to use those features and they will be monitored throughout today's webinar. So with that, Andy, one of my favorite topics, good governance,
Awesome.
county board rules. Let's go ahead.
Awesome. Thank you, Sarah. That was a very kind introduction. I think this is probably the third session we've done on board rules, which speaks to, I think, the interest in this topic. I know you get a lot of questions about board rules and governance. I certainly get a lot of questions about board rules and governance. And so right now is a great time to really dive into some of the topics contained within the board rules because we know a lot of counties are right now looking at updating their board rules in anticipation of the election right around the corner in 3 months. And so, good time to address this. And I also want to point out another housekeeping item is for everybody. Look at it, it says solid rules, solid boards. It's board rules, BOARD, not BORED. I think a lot of people, when they hear the word rules, think, oh, that's boring. This is anything but boring. These rules define and provide a foundation for good governance. And so, as Sarah indicated, it's a topic near and dear to both our hearts. And the reason is because when you do it the right way, counties operate a lot more efficiently. We have governance that is predictable, that is efficient, and everything goes according to Hoyle. And that's essentially what we want to provide to counties is this platform to create a successful environment for governance. As Sarah mentioned, I don't have a PowerPoint slide deck today because we're going to go through the template board rules that WCA has put together, but I've got a couple of introductory points that I want to make before we do that dive. Understand, first of all, first and foremost, board rules are not one size fits all. So even though we have a template that we're going to share today and it's shared at WCA's website, wicounties.org, that template is not a look at it and adopt it. That template is a conversation starter. What do we want the rules in our county to look like? And every county is going to be different. Your board rules, your governance structure, the way you operate ought to reflect history and tradition within your county as it relates to the county board and also reflect the values within your community. So each and every county is going to be different, and we celebrate that distinction, those differences among the various counties because it's really fun to see how different counties do things. Understand too that when we're dealing with board rules, we want to encourage readability. Why do we want to encourage readability? Well, think about the audience for the board rules. Of course, it's the county board. And we want the county board members, whether they're new or veteran, to understand the rules, understand where to look to get at certain rules, to understand certain information. But as well, it's a communication to the public. And what I mean by that is that if we let the public know that we've got an established set of rules that are readable, understandable, and that we follow, the public, I think, has more faith and trust in the very important work that we undertake. If we look like a disheveled mess, then the public is not going to have a lot of faith that we know what we're doing. If we look like we're organized, we've got things in readable format, we know what we're doing, then the public is going to have a lot of faith and trust in what it is that we have to do in terms of the important county business. Now, is it easier to get things done if the public has trust in what we do? Absolutely. So we ought to take measures, no matter how small, to reinforce and encourage that sort of faith that the public puts in us. Enforceability is important because I get this question awful lot. I know Sarah does too. What happens if somebody violates the board rules? What happens if we have somebody acting out of order? What happens if? What? We're going to address that. It's not easy. It's a difficult concept to get through. We've had separate in the boardroom presentations devoted to what to do with one of our members of the county board that's misbehaving and so on. So we'll get into how the board rules can help establish an enforceability mechanism. Understand that it's difficult. But again, I go back to this whole concept of it being the foundation of good governance. What we want is a set of board rules to be self-executing in terms of their enforceability, that people have an understanding of those expectations and that they meet those expectations. And so I think having good board rules is going to help us as it relates to enforceability. Now, again, board rules template, it's out there. Big thank you to Richland County. In 2024, they undertook a significant rewrite of their board rules. And in that process, when we were working with Richland County, I had a conversation with Sarah and said, you know what? This is the most comprehensive work I've ever done on the topic of board rules. They've allowed us to operate from a clean slate and say, if you were going to build out board rules in a perfect world, what would they look like? And that was the foundation for the template. And so thank you to Richland County for being the ultimate guinea pig when it comes to board rules. Now, that being said, Richland County Board made some decisions that other boards may not make as it relates to inclusion, exclusion, modification of the board rules. So we created the template, and that template has certain choice points that we're going to talk about in just a little bit. We've updated that template last fall in 2025. We updated that template, and I guarantee you that we will update it further as additional issues, thoughts, and ideas come to light. So we will continue to update those template rules, and it is going to be a living, breathing document. I'm going to say this again, even though I've said it before, it is not a cut and paste job. Think about what the template is saying in terms of the rule and how it is that you want the rule to operate in your county. So without further ado, let's talk a little bit about the rules of the board. All right. We, of course, have a table of contents. The reason I'm stopping here instead of diving right into the rules is I want you to notice the sections that we've divided this template into. We've got purpose and definitions, county board organization, county board officers, and then rules of procedure, and then enforcement. The reason I point this out gets back to the point I made earlier about readability and organization of our board rules. We should have the ability, depending on the topic that's in our mind, to be able to figure out where in our board rules that topic may be addressed. And so it's important that we organize our rules in a very coherent fashion so that we have the ability to get at the rules as needed. So first, purpose and definition. It's pretty self-explanatory in terms of how this section operates. It's basically what do these rules do and what are they there for? Again, remember I said that the board rules are a communication to the public. And so take the opportunity within the board rules to reinforce important points about the work that we do as counties and as a county board and how it is that the citizens are impacted by the decisions that we make. You'll see right here on purpose that the board recognizes citizens' rightful expectation that the financial resources provided the county through tax levy and other sources be invested in a wise and deliberate manner. Is that required for the board rules? Absolutely not. But is that a statement that again reinforces the trust and faith that the public is going to put in us to make really important decisions? Sure. So that's an example of something that could be in our purpose and definition section. Then we get to county board organization, and you see a footnote under section 2. These board rules do not make the self-organization election that's allowed under 59.10 of the statutes. I know many counties put the self-organization election in their board rules, and that's fine. Regardless, Sarah, me, WCA would encourage every county to elect self-organization. What does that mean? Two very important points in my mind is that it allows county boards the freedom to determine supervisor compensation without the restrictions in 59.10. It also allows county boards to define how vacancies in a supervisor seat on the county board are filled, again, without reference to the restrictions contained in 59.10. That's what self-organization gets you. There are no required annual filings. There's nothing else that the county is required to do. All you need to do is have an ordinance on the books that says we elect self-organization, send a copy of that ordinance to the Secretary of State, and boom, you're self-organized. Under county board organization, we start with county board meetings and we start with recognition of the required meetings. The first one that everybody's going to be familiar with in 3 months is the organizational meeting. That has to happen by statute on the third Tuesday in April in even numbered years following the spring election. All right. In that meeting, we are going to organize and transact general business. In other words, we can put items on the agenda that are just general in nature that we would handle in any other board meeting, but we're also going to elect officers. All right. We elect a board chair, we elect a vice chair. Under 59.12, we have the duties of the chair and the vice chair that again we'll get to in a moment here as we go through these board rules, but this happens at the organizational meeting. Now, what we typically see happen at the organizational meeting as well is that there is a process for populating the committees. Different counties do it different ways. And I often get asked the question, what do most other counties do? And unless Sarah disagrees with me, I don't think that there is a majority of counties that do it a certain way because there are always little twists that get added on about that appointment process as it relates to committees. Now, in statute, it says that the county chairperson, with the consent of the board, can appoint the committees, and that's just fine. But also realize that 59.03 of the statutes, which I've often referred to as the Freedom Statute, allows us to organize in administrative affairs the way that we see fit as a county. So we take advantage of that through these board rules by providing a process for populating committees if we want to do it a different way. And so some of the different ways that we've seen is having a committee on committees populate those various committees. We have board chairs that appoint committees subject to board confirmation, or we even have existing committees of the boards, for example, an executive committee that may populate those committees. Again, it's up to each individual county as to what process is going to work. Now, understand too that even though I've said all of this about the freedom to organize as we see fit, that there are statutory restrictions on certain committees. For example, there is an election of highway committee members unless we have opted out of that election process. There is a process for populating, for example, a human services committee in terms of who is required to be on that committee. And so we have to be cognizant of the statutory restrictions, but otherwise we have a heck of a lot of freedom. Now, I've talked about statutory restrictions without giving you a list of what all of those are, which is why you see in big, bold red letters at the top of the template board rules, talk to your corporation counsel. Please talk to your corporation counsel because the last thing we want to do is go through the effort of putting things together only to have corporation counsel say later, hey, we got to take it all apart because we didn't follow the right process that is dictated by statute. So whenever you're going to go through the rules, whenever you're going to go through committee assignments, whenever you're going to go through committee structure and organization, please consult with Corporation Counsel. And to the extent Corporation Counsel has questions or you would like further input, feel free to reach out to Sarah, reach out to me. We've worked with an awful lot of counties on board rules and committee process. All right. So we have the organizational meeting. At the organizational meeting, who is the chair? That's a great question because after the election, the current board chair may no longer be a county board supervisor. We know that the current county board chair is not the county board chair until he or she is elected at the organizational meeting. So who chairs that meeting as the temporary chair for purposes of conducting that organizational business? Again, it's up to each county as to how that happens. In addition to the organizational meeting, the statutes 59.111A requires an annual meeting. And so we have an annual meeting in November every year. And then we have regular meetings of the county board. I think historically, this is an example of where Chapter 59 of the statutes has not kept up with the times. It used to be that county boards met a lot less regularly than they currently do. It may have been that a county board only met two, three, four times during a year and otherwise didn't get together for official meetings. Now we know that in most situations, county boards meet monthly, if not more often. So what we want to do is provide for what regular meetings look like. Let's establish in our board rules the time for the meetings, the date for the meetings, and so on. And so that is a great opportunity in the board rules to define that process. And then we have special meetings. 5911 sub 2 allows certain supervisors, a majority of the supervisors, to have a special meeting. And that's done on a written petition that's signed by the supervisors, submitted to the clerk, and so on. Absent that sort of petition, do we want the ability to call a special county board meeting? And if so, who can do that? I like the ability to call a special meeting because we don't know what type of business is going to come up that's going to require a meeting. And so you'll see within the template board rules that we have the ability to call a special meeting at the call of the board chair. Again, it's up to you as a county as to how you want to define that process, but I think it's very important to have a process defined. Section 2.02, board meeting agenda responsibilities. I want to first point out that 59.23 of the statute says that the county clerk is responsible for preparation of the agenda, and preparation of the agenda is different than what is in the agenda. And so we often get asked the question of who controls what's on the agenda? Well, as the presiding officer of the county board, absent any sort of rule, the county board chair is responsible for what goes on the agenda. Of course, the county board chair and his or her determination can be overruled or modified by majority vote of the county board. But that's awkward because then we get in a situation where in a meeting, somebody's going to ask that something be placed on the agenda, the board chair says no, and then we have a vote and it's messy. Again, we get back to this point where the public viewing that type of meeting is going to say they don't know what they're doing. This is ridiculous. Why can't something be on the agenda? Again, we prefer that the process for getting something on the agenda be contained within the board rules, and that's exactly what this section 2.02 does. So we have who can put things on the agenda, and then I see that I've got the indenting wrong on this. We can fix that, Sarah. But then what happens once we have the agenda comprised? Do we have a board packet that goes out before meetings? And if that board packet does go out, when does it go out? And that means that the timeline for submitting things to be including in the board packet is going to have to be established. So all of that is addressed here in section 2.02D. Again, put it in language and timing that fits your needs, but let's address that topic within our board rules. County email addresses, 2.03. This is a topic very near and dear my heart as a lawyer, is that when I get called in to assist a county with a public records request, and that records request has asked for all emails from a supervisor or county board as a whole to various different things, I don't want to have to go around and search people's personal emails. I would rather that all county business be conducted on a county email address. That way I can have a conversation with IT and say, just give me the emails with this date delineation addressed to so-and-so and go from there. So we want all county board members to use their county email address for official business. And you'll see right in this template board rules that there is a prohibition. It says supervisors shall not conduct county business on any other email address. Then we get into committees of the county board and other boards and commissions, creation and existence. We know that there are several committees that are required by statute. We also know that there are several committees that aren't required by statute, but we have them and we need to have them just to operate as a county board day to day. And so in 2.04, we have the delineation or the separation about what those various committees, boards, or commissions are. And you'll see them organized into basically three different categories. We have the standing committees of the board. Those standing committees are going to be the ones that exist perpetually from board to board. And even though we have an election in even numbered years in the spring, that the standing committees are going to continue to exist until the board takes action, taking those standing committees out or restructuring. We also have ad hoc committees. Ad hoc committees serve as a temporary body that is going to address a specific issue and will be discharged once that issue or issues is addressed. And so we have the recognition that there may be ad hoc committees from time to time. And then we have other boards and commissions. And what I'm thinking of there is that, again, statutorily, we're required to have certain boards or commissions. I think about a human services board, for example. Statutorily, we're required to have that. I also know that many counties are party to a 66.0301 intergovernmental cooperation agreement. And sometimes those agreements create a commission to govern the affairs of that particular commission and a particular agreement. And so membership on that commission, for example, could be addressed under other boards and commissions. The reason I'm saying all of this and bringing all of this up with other boards and commissions and the ad hoc committees especially is that it will change from time to time. You're getting that impression based upon my discussion that this isn't going to be consistent year over year, decade over decade. And so what we did with the template rules is we said, look, we're going to address committee structure, committee responsibilities, ad hoc committees, other boards and commissions in what's identified as the Appendix A to the rules. The reason that we do that in Appendix A is that there may be opportunity to modify, for example, what the ad hoc committees look like, what their charge is, what the other boards and commissions look like, what that charge is, and for that matter, what the standing committee's charge is. And we want to do it without having to reopen the entire set of board rules. We just want to address committee structure. Well, having it in Appendix A allows us, and we want to recognize that Appendix A can be modified from time to time, perhaps by majority vote. You don't want to require a two-thirds majority, for example, in that circumstance, uh, potentially. But we can modify that without having to reopen all of the board rules. The other reason I like that is that I've seen some county board rules that go on page after page after page talking about committees. And so it gets lost. It's hard to read, it's hard to understand, it's hard to follow. So having it all in one spot in Appendix A seems to make organizational sense to me. So again, take a look at that opportunity to create that Appendix A. Then we talk about how we've talked a little bit about how committees are populated, but then what about how they're removed? All right. How is somebody removed from a committee? Who ultimately has the responsibility for removal if somebody is acting in a way detrimental to the committee's affairs? Under the law, the power of appointment carries with it the power of removal. That's just a given under the law. It's not stated in any statute anywhere. That's just a given under the law. So with that said, we're better off addressing it in black and white in the board rules, exactly how a person is removed from a committee. And the county board has the ability to define what that process looks like. And you'll see here that there are all sorts of opportunities for choice within 2.05 about exactly how that is all going to take place. So again, encourage counties to take a look at those different provisions to see what perhaps other counties have done and figure out what's best for your county. Meeting agenda responsibilities, similar to what we dealt with the county board, we want to establish a hierarchy and protocol for establishing committee meeting agendas and who's responsible for that. Next, we get into county board member compensation. If you are self-organized, you as a county board have the ability to determine what board member compensation is, and you put that right within your board rules. If you have not self-organized, and again, we encourage everybody to self-organize, but if you have not self-organized, 59.10 of the statutes has some restrictions on how county board members can be compensated. Really encourage you to have a discussion with Corporation Counsel about your options in that regard. But what we see here is that we see separation of the various activities in which a county board member is involved and what compensation is going to attach to those activities. For example, if a county board supervisor is not a member of a committee, but he or she attends a committee meeting, are they entitled to a per diem for that? Let's spell that out in the board rules and make it clear. Um, Let me see here. Mark asked a question. I'm reading a question right now. Mark asked a question about 5911 specifies the rules for calling a special meeting, but suggests the county can establish other procedures such as at the call of the chair. Can we clarify that a county is not limited to the 5911 procedure and can expand on that? And if that allowance is only for self-organized counties? Great question, Mark. It's not limited to self-organized counties. And the 59.11 language, we've not interpreted that as the exclusive means by which to call a special meeting. Statutorily, you supervisor can use 59.11 in that process for calling a special meeting, but the county under 59.03 and its status as being a administrative home rule authority has the ability to define a separate rule for allowing a special meeting to be called. So thanks for that question, Mark. Expense reimbursement. This is something that frankly is going to change from time to time depending upon the circumstances. What I mean by that is that the IRS mileage rate is going to change. The amount that we want to pay for hotels, lodging, or meals is going to change. And so this is a situation where we like to see delegation to, for example, the Finance Committee or the Executive Committee to establish a policy for expense reimbursement. And so that gives the committee the ability to modify that policy as needed from year to year and so on. And so it's important that we recognize expense reimbursement process within our board rules, but the actual policy itself is something that we would like to see delegated to a particular committee. Meeting minutes, 59.23 of the statute dealing with the county clerk says that the county clerk is responsible for preparation of minutes for all meetings of the county board. But what about committees? All right. The clerk is also responsible for committee meetings, but that doesn't mean that the clerk can't delegate that authority. So in some counties, we know that department heads take minutes of meetings. What's important in our mind is to have an established format and protocol for taking the minutes, what they look like, filing those minutes, approving those minutes, and so on. That is the official record. Those minutes are the official record of whatever happened at a board meeting or a committee meeting. So it's important that we have continuity, clarity, consistency with those minutes, and that all happens through working with the county clerk. Seating arrangements. Believe it or not, this is a topic that's come up from time to time about complaints where people are seated as the county board. It would be awesome in our board rules to address seating arrangements. Are people going to be organized alphabetically? Are they going to be organized by district? Are they going to be organized at random? How is that going to be established? When are we going to change that? Is that every 2 years? Is it every year? And so on. And then for that matter, where are our officers sitting? Are we going to have corporation counsel up front? I think that's a really good idea, by the way. Clerk up front with the officers. Anybody else up there? Where are we going to have press seated? Is press seating going to be in the audience with the rest of the public? Let's address those types of issues within the board rules. Next section, 2.10, board member interest form. And this is a topic that has come up from time to time in counties. And I think it's a good idea, but I can also see arguments as to why people don't have these interest forms filled out. Essentially, an interest form is going to give the board chair or the committee on committees or whoever's responsible for populating committees an idea of people who have experienced an interest in particular areas where we can place that person into a committee that matches their interests. And so it would be really cool to have board interest forms to help us and guide us in that deliberation and discussion about what committees are appropriate. So again, you'll see it all italicized here because different counties do it different ways and we don't have strong feelings as to what works in your particular county, but it's also worthy of further discussion to see if it would work. 2.11 is an important board rule. I say this because I go back to Carver policy governance. And if you've ever dealt with Jonathan Carver on policy governance, it's a very complex set of rules about how governmental bodies and nonprofit organizations ought to be organized from a governance perspective. The reason I go back there is that the preeminent rule in the Carver model is the rule that defines the relationship between the executive and the legislative branch, the administrator, executive, or administrative coordinator, and the county board. And so, thinking about this in our board rules, let's establish what that relationship looks like. And again, it can be very, very simple. It's one paragraph in our template here. You may want to expand on that, and that's fine. But at least let's address this in our board rules so we set expectations about what is appropriate in terms of that relationship between the board and board members and our executive or administrative branch. Vacancies in the office of a county board member. We know that there is a specific process in 59.103E of the statutes, but we also know that if we've elected self-organization, that we get to define what that process looks like. And so you see a couple of choices within the template in section 2.12 about how that process is utilized. 2.13 official statements by board members. I think it's really important to say in the rules who's authorized to speak on behalf of the county board. It ought to be the board chair. Why do we have this statement in here? Number one, it lets other supervisors know that they're not authorized to make official statements. But number two, remember, if these rules are published, they go out to the public, then the public knows who has the ability to speak on an official matter pending before the county board or that the action that the county board took. Closed session at committee meetings. We get this question an awful lot. Who can be in a closed session committee meeting? Can a board supervisor who's not a member of the committee be in that closed session? We have a statute on the books, 19.89 of the statutes, that says in the absence of a rule or policy to the contrary, that a supervisor who is not a member of the committee has a right to be in that closed session meeting of a committee. And so in 2.14, if we think it's important to be able to excuse a county board supervisor from a closed session, let's identify that within our board rules because otherwise the statutes say that we cannot exclude that supervisor. I'll give you an extreme example. This has happened in a couple of different counties where we had a board supervisor actually suing the county. County board committee wants to go into closed session to discuss that lawsuit with legal counsel. And we had to allow that county board supervisor in the closed session, the very one that was suing the county. Now, how long do you think that discussion lasted? Not very long at all, but we didn't have the ability to convene as a group to talk about our legal strategy on the case because we had to let the other party, the adverse party in the lawsuit, into that meeting, which was incredibly frustrating. And so let's put a rule on the books if we want to address that. Now, different counties do it different ways in terms of who can be excluded. Sometimes it's the committee chair, sometimes it's by vote of the committee. Sometimes we have to express reasons as to why that person is not being let in, and so on. So it's up to you as to what works, but I really encourage counties to take a look at a rule like 2.14 here about exclusion from closed sessions. So with that, we get into county board officers. And before we do that, I want to address a couple of questions that have come in as well, separate and apart from what we've got here. The first question I've got is that in setting board member qualifications, can counties place restrictions on family members or spouses from serving together on the board? The answer is no. The statutory qualifications for being a board member are contained in statute, and we cannot add to those qualifications. The question I have is if I assume somebody's living with their spouse, and so I think there would be a prohibition on dual service there because presumably they both live in the same supervisory district. So be very careful about qualifications that we may want to place on membership on the board because the statutes don't allow us to place additional qualifications. Do most counties have their committee chair elected by committee members or selected by the board chair? I think in most of the counties that I work with, it's either selected by the board chair or the committee on committees. But I have seen counties where the committees themselves elect their committee chair. No preference either way. It's really up to the county. And again, the history and traditions within your county as to what works best. So those are the questions that came in otherwise. Let's talk a little bit about county board officers. I talked about county board chair. The duties of the chair are contained in 59.12, sub 1 of the statutes, and we have a board vice chair, and those duties are contained in 59.12 of the statutes. Now, some of the choices that we have, where I've seen counties have rules on the books, are questions concerning, well, if we can't meet quorum requirements in a particular committee, can the board chair fill in on that committee as a voting member? Yeah, absolutely, you can do that. If you're going to do that, let's spell that out in these rules and let's be specific about what the authority of the board chair is in that circumstance. So again, the template rules contain those sorts of considerations. If we want to have additional officers, for example, I know some counties have a sergeant at arms, we want to identify that particular officer position within this section 3 of the rules. All right. Rules of procedure. Parliamentary authority, I have this highlighted because this is really important, is that we are governed by state statute. We are governed by these board rules. In the absence of addressing a topic within state statute or the board rules, we go to Robert's Rules of Order. It's very important to understand the hierarchy here, is that Robert's Rules of Order provides us with parliamentary authority, rules of procedure, but then we can modify Robert's Rules of Order through the board rules, but neither the board rules nor parliamentary authority can be contrary to state statute. A great example of that is the open meetings law. There is a requirement in the open meetings law about publication of an agenda at least 24 hours in advance of a meeting. Publication of notice of the meeting, which contains the agenda, has to be 24 hours before the meeting. Board rules, Robert's rules, you can't modify that. And so we have to follow open meetings law, but it's important that we identify parliamentary authority here. Mary had a question here real quick. Can committee members, once they know who's assigned to a committee, call other supervisors to ask them to vote for them as a committee chair, or is this a violation of the open meetings law? It brings up a great question. I get asked this question every 2 years and even numbered years about how much politicking can somebody do in advance of the organizational meeting for the position of board chair or vice chair. Great question, because there is no exemption in the open meetings law that deals with officer candidates. And so I can't tell you that it's okay to politic and go around and ask for people's vote and have discussion about being board chair. At the same time, if board chair or somebody who wants to be board chair simply calls somebody and says, hey, I'd like you to vote for me, and hangs up the phone, that's not a violation of the open meetings law. That's a one-way communication. The thing that I like to see is a robust opportunity for the candidates to present their qualifications and desire to the body at the organizational meeting. If we provide that forum, if we provide that opportunity, in my mind, it minimizes the ability or the, I guess, effectiveness of somebody politicking prior to the meeting. And so I would very much prefer to have all of that done in an open session, open environment at the organizational meeting. Second, in rules of procedure, committee of the whole. I know some counties rely upon meeting as a committee of the whole in order to discuss items without having to have an item of business pending before the body. If we have a committee of the whole, which is, again, it's addressed in Robert's rules, but let's have a rule on the books as to how we are going to utilize the committee of the whole procedure. Remote attendance at meetings. There is no statute that gives somebody a right to attend a meeting remotely, a board meeting or a committee meeting remotely. There is nothing within Robert's rules saying that you have that right. But what Robert's rules says is that if you have a rule on the books that relates to remote attendance at these meetings, then that person can be considered present for all purposes. So what that tells us is that we have the ability to shape the rules surrounding remote attendance at meetings. All right. Again, the template contains language that we utilized an awful lot during COVID. These are just rules of thumb that we came up with in consultation with the Attorney General's office and other counties about what was working. You can feel free to utilize some, all of this language, none of this language, but I would really, really encourage everybody, if you're going to allow remote attendance at meetings, let's adequately define what that looks like. All right. So again, let's address that in your board rules. Then we have here order of business. And again, this is something you can modify as you see fit, but it's important in our board rules to have the established agenda here. Every single county board meeting agenda ought to look like what the template looks like in the board rules. The reason I say that is we are establishing expectations for consistency. We are establishing expectations for predictability, and we are letting everybody know what our county board meetings are going to look like. So let's have the order of business identified within our board rules. Same thing goes for our committee meetings. We want to have that order of business identified and published in our board rules. Approval of minutes, consideration of resolutions, those are just special items that we put in here as it relates to the order of business. Personal electronic devices. I love this rule because I've been in so many meetings where I see important business coming before the county board, and I see a county board member taking out their phone and doing this, this, and this, and doing all sorts of things. That's counterproductive. Again, it leads to distrust in the public. We don't know what's being said on that personal device. You may have some enterprising member of the press or public ask for the records generated on that phone as a result of the texting that was going on during the meeting. That's actually happened. So let's say all personal electronic devices are put in silent mode and put away during the meeting. Doesn't mean that somebody can't use their county issued iPad or other electronic device to conduct official county business during the meeting. They can, but let's put away all of our personal electronic devices. Recognition, debate, and voting. Again, there's a process that we've got. It's in Robert's rules about how somebody gets recognized, but according to Robert's rules, you should stand and ask for recognition. I can tell you that I've never seen that happen at a county board meeting in my 31 years of doing this, so I doubt that it happens. Usually we have an electronic system for recognition, and if we don't have an electronic system, it goes by raising the hand. That's fine. Whatever it is, let's put that here in our board rules. Debates. We know that under Robert's rules, people are entitled to speak twice for a total of 10 minutes per instance. So 20 minutes total. Robert's rule says they have the right to speak on a motion or an item of business pending before the board in that time frame. But if we want to modify that and say, okay, it's twice for a total of 10 minutes, not 20 minutes, total of 10 minutes, or it's twice, no more than 3 minutes each. I mean, you can do that. Now, you also have the ability to modify the rules of debate, and that's recognized in here. If that member asks for permission from the board chair or asks the body for permission, they can certainly exceed whatever time limit we put in there. Abstention. This is a topic that's generated quite a few questions over the years as well. Can anybody abstain from voting? Absolutely, they can abstain from voting. That's their right to abstain. Can we have in the board rules that they have to take a vote? No, we can't put in the board rules that they are prohibited from abstaining. But at the same time, might it be good governance if we have somebody explain on the record why they're abstaining? It might be. And I've seen counties who have that rule on the books, and that's just fine. Again, what works in your county is what you should utilize. And again, it's making sure that the public has faith in what it is that we're doing as a county board. Public decorum and comment. All right. Now, this is a set of rules in 4.07 that goes beyond rules applicable to just the county board. All right. Public decorum and comment applies to everybody in attendance at a county board meeting or a county board committee meeting. And so I like to see these in the board rules to, again, a couple of reasons. First, make them semi-permanent, meaning that these are the rules that are going to apply each and every meeting. Everybody knows what they are, they're predictable. But second, to put the public on notice of expectations when they attend a meeting. That way, if we need to enforce the rules, we can say these rules have been on the books for a long time. Everybody understands what these rules are. We have somebody who violated, and there are consequences for that violation. What are the consequences? Well, in an extreme example, you can ask the sheriff's office for assistance in escorting somebody out of a meeting or citing them for disorderly conduct. I've had conversations with sheriff's offices who have told me that it is their high preference. They prefer to have a board rule on the books if they are going to enforce decorum at a county board meeting. All right. So again, that tells us that we should address this topic within our board rules. That said, this is an area that you really need to talk to your corporation counsel about. We have this thing in this country called the First Amendment. We can't have a rule on the books that violates somebody's First Amendment privileges. So we have to be very careful that the rules that we put in place are not infringing upon somebody's First Amendment rights. And we have to make sure that our implementation of these rules doesn't abridge somebody's First Amendment rights. So I really encourage you to have conversations with corporation counsel about those rules. Excuse me. Public participation at meetings. The public has a right to monitor our meetings. They do not have a right to participate in our meetings. I've seen county board meetings where a board member will turn around, ask a member of the public a question, and a member of the public responds to that question. In my mind, that's inappropriate. If we need input from the public, we have to request permission through the chair and perhaps the body to allow that person to address the board with their information. Everything ought to be, all the communications ought to be within the board and not involve members of the public unless that member of the public is granted permission. Now, one circumstance where it's not just members of the board is where, for example, we are receiving a report from the highway commissioner. The highway commissioner is not a member of the board, but that's a circumstance where the board's granted permission to the highway commissioner to provide information to the board. So again, let's address these sorts of topics within our board rules. Reconsideration. I got a question in advance of this discussion. Why are we addressing reconsideration within our rules? Well, this is a topic where in Robert's rules it says that a matter is subject to reconsideration at the meeting where the matter is disposed of or at the next following meeting. Remember how I said the open meetings law impacts Robert's rules? Well, the open meetings law tells us that we have to have notice to the public 24 hours in advance of a meeting of a topic that we're going to consider. Well, what if the board chair isn't going to put reconsideration on the agenda? Well, we have to deal with this issue. If we know that a reconsideration motion is going to come up, we have to give the public notice of an item that's going to be reconsidered, and we ought to have a process for making sure that it's on the agenda. So again, we want to address that topic within our board rules. Resolutions, form, and introduction. Who can introduce a resolution? Does it have to go through a committee? Does a committee have to vote favorably on a resolution for it to come back to the full board? These are all questions that we need to answer in the context of these board rules. Again, defining that process so that we all have an understanding of the flow of business through the committee process and up to our county board. I like to see on every resolution a space for a fiscal note where our administrative branch or finance officer can designate exactly what the fiscal impact of a particular resolution is. I also like to have a space for a legal note. I want to make sure that that resolution has gone through Corporation Counsel's office to ensure that it conforms to all of the requirements that we have for resolutions, and as well that we're not taking action that Corporation Counsel believes to be contrary to state or federal law. Um, Again, talking about introduction of resolutions, how do those resolutions get introduced and get on the board agenda? And then finally, we have this concept of suspension and amendment to rules. The rules of procedure from time to time, and it should be rare, but it does happen from time to time, where we want to suspend the application of a particular rule. So we want to have a process in our board rules for suspending those rules, and it ought to be by supermajority vote. That's two-thirds vote as identified within the template. You can make it three-quarters if that's what you want to do, but we want to have a process for suspension of the rules. Amendment to the rules, same thing. We want it to be by supermajority vote. Now, all of this being said, I want to make a very important point here that's not in the template. I like to see the board rules codified in ordinance. It gives them a feature of permanence. It gives them a feature of enforceability that assists with what it is that we are trying to accomplish with the board rules. I know some counties don't want their board rules in ordinance, and that's okay, but understand that if they are in ordinance, if they're codified, that we have, again, a permanent feature of the county code devoted to the rules of governance associated with our county board proceedings. So again, I think that's important. Now, there are additional rules that we may want to consider. They're not contained within the template, but I've heard this concept addressed from time to time by several counties. And where I find these, these issues addressed and these questions arising is in people not understanding the distinction between an ethical issue that is addressed under our code of ethics, a conduct issue, which is addressed through our board rules, and a morality issue, which is not addressed. What I always like to say is let's make sure that we keep those three different topical areas separate. If we have an ethics issue, we are going to deal with it through our ethics ordinance. If we have a conduct issue, we are going to deal with it through our board rules. And if we have a morality issue, we're not going to deal with it because there is no way that we're ever going to be able to adequately deal with it. All right. So again, if we're going to deal with conduct issues within our board rules, we have to establish what the rules of conduct are. So you'll see in the template that we've got examples of expectations for board member conduct. All right. And it goes through both in a meeting, outside a meeting, and dealing with the public. Those are all the sets of expectations for each board member. And if they violate those rules of conduct, then the consequences are going to be as addressed within the board rules. So then we do get to this concept of enforcement and consequences. And this can be challenging because it's not as though we have the ability to kick somebody off the board. To kick somebody off the board, we have to follow the Chapter 17 process of a due process hearing and so on. So it is a monumental undertaking to quote unquote kick somebody off the board, and it can't be automatic within our board rules. So we have to have an enforcement mechanism with enough teeth to get people to understand that there are consequences for violating the board rules, but at the same time understand that there are limitations on what we can do. So you'll see here in the procedure for enforcement, we have delegation to a particular committee to investigate and figure out what happened and determine what appropriate sanction is going to be warranted, but then it is the board that decides what that sanction is going to be. In other words, if we have rules of conduct that apply to board members, it ought to be the entire board enforcing those rules of conduct, not just a subset, a committee, for example, because it's the entire board that has an interest in the governance associated with your particular county. So here in sub B, we have a list of the various sanctions that can be imposed for violation of the board rules. And it goes all the way from the least intrusive to the most intrusive. Private reprimands, censure, censure with a formal resolution, removal from position of committee chair, removal from a committee, and referral to a committee for investigation to determine if there's cause to remove somebody from the board. All right. So again, we have a process for enforcement of these rules. The goal with this entire process is to hopefully set expectations so that people follow the rules, not that we have to constantly enforce the rules. So I'm hoping that by having something like this on the books, we can avoid the really ugly, heated, and difficult discussions associated with violation of the rules and enforcement of the rules. Again, it's establishing those expectations. So with that, we've gotten through the entire template set of board rules. I feel like I was speed talking for the entire time. And the reason I was is because I know in prior discussions on board rules, we weren't able to get through all the topical areas. So this particular in the boardroom session was designed to give you insight as to why it is that the template board rules are organized the way they are, tell you what they do, and give you a sneak peek at the different options that exist for you to consider. Again, if you have questions about what's going on in your county, if you have questions about the application of a particular rule, if you have questions surrounding why the template is structured the way it is, reach out to me, reach out to Sarah, and we'd be happy to go through that with you. I know that Sarah and I have both been through several counties' historical, I want to say, set of board rules. I say that because I know they've been on the books for a long time. They are, and this is a legal term, they are a disaster. I say that because they're disorganized. We've had rules that have been added to, modified, deleted from time to time. We've got other rules that have been inserted in weird places from time to time. And this is not to say that it's the fault of the county board. I say that because historically, county boards have had an issue that they need to address. They put it in their board rules and they do their level best at putting it in there in a spot that they think makes sense at the time. The problem is that 10 years later, when you take a look at that same set of board rules, it seems nonsensical and disorganized. So really encourage counties to, you don't have to start from scratch. You can take your current board rules, but take those current rules and see how they fit within an organized form like this template, because it makes life so much easier for board members and others that are interested in county board governance. So with that, perhaps I'll pause and see if Sarah, you have anything you wanted to add about board rules. I know it's a topic that you've been dealing with an awful lot, and otherwise open it up to questions from the audience so that we can get you the best information you need to come up with a good set of board rules.
Nope, I don't think I have anything to add, Andy, other than to say that as counties are working through their board rules, prior to their April organizational meetings. I know I'm available, Andy is available as well, to review your board rules, to answer any questions that you may have as you are looking to make revisions to your board rules. Andy, I don't even know how many sets of board rules you and I have read since last fall, between last fall and today. And I know I've
Quite a
got
few.
one or two more sitting on my desk yet to get through.
Quite a few. There's been a lot. And you bring up a good point, Sarah, because we have the organizational meeting right around the corner. And I get asked often, well, do we adopt these board rules at the organizational meeting or do we do it before? Typically, you want to establish the rules at the organizational meeting. Here's the challenge. You're asking a bunch of new supervisors to adopt rules that they haven't even read. All right, is that fair? So typically, I would like to see the board rules adopted in March and then have a training session on those board rules at the organizational meeting or shortly thereafter. So it's a bit different than what Robert's rules would suggest in terms of timing. But to me, it doesn't make any sense to ask a newly seated board member, hey, adopt these rules. I know you haven't read them, but let's just adopt them. Sarah, do you have any thoughts on that?
No, I agree. It's one of those things where if they are established prior to the election, I think it becomes easier for a newly elected supervisor, to know what to expect as best they can at their first meeting of the county board. That being said, I do see, another side of the discussion, of course, which is the board that is going to be subject to those rules should adopt those particular rules.
Exactly.
So
Exactly.
yeah, it's interesting. I will say I see. Um, some counties will adopt them at the organizational meeting, some will adopt them prior to the organizational meeting. I have seen counties that don't even review their county board rules for years or sessions at a time. And I would highly discourage any counties from not at least taking a look at their board rules every 2 years because I think it's important for those to be, they're kind of living, breathing documents like the Constitution in a sense. Things are always changing within your county. Don't wait 10 years to take a look at your board rules again, but instead, I think at a minimum, every 2 years, you should be taking a look at these rules. Um, it's usually something happens in the course of a 2 year period where you may want to address something in your rules that had you had a rule on that particular issue would have helped you work through something a little more smoothly. Andy, I see we have a question.
Yeah, Tiffany asks, and this is a great question. Do county boards tend to have rules to guide participation in committee meetings? For example, if a supervisor is not on a standing committee but has an interest on a topic on their agenda, are there rules that allow that supervisor's participation in the meeting, or is that generally just left to the committee chair? Well, under Robert's rules, it's left to the committee chair. If that supervisor is not a member of the committee, they have no right to speak at the meeting. The question then arises, are you going to force them then to offer their thoughts during public comment? And that seems counterproductive as well in my mind. What I would prefer to see is that that supervisor be given the ability to speak on a topic of interest with the permission of either the committee chair or a majority of the members of that committee. They shouldn't be given the right to speak because that could be disruptive and they are not a member of the committee. At the same time, we ought to recognize that supervisor has a status that's separate and distinct and I guess elevated from that of the general public, meaning that they have a vote on the ultimate issue that comes back to the county board. So them expressing their feelings, beliefs, information on a particular topic at the committee level ought to be encouraged. So yes, I'd like to see a rule on the books in the board rules dealing with participation in committee meetings. Everybody's an expert on board rules by now, sir. We're not going to have to address this for another 5 years.
That's great. That's
We don't
great.
have we don't have any pending questions.
No
Um,
pending questions.
I'm trying to think if there's anything that we neglected to address, and I'm sure there is. I'm sure people still have questions, but thankfully they know how to get in touch with you, get in touch with me, so we can help with those questions. But hopefully you use the template, and that's a solid guide for you in the process of updating your board rules.
Yeah, and I think Andy, this leads into our February topic. which is the county organizational meeting.
Oh, that's gonna be a fun one because we do this every 2 years and we get all sorts of really interesting questions on organizational meetings. I can tell you, I've had the privilege of temporarily chairing organizational meetings in several counties, and it makes me feel really super special and important to sit up there in that seat with a gavel. But I only get to do it for about 10 minutes until the board chair is elected.
Yeah, so again, February 25th, we'll be discussing. Our next in the boardroom on February 25th, where we will be discussing the county organizational meeting. That one's always fun. I know years ago, we started talking about this years ago when we started getting a lot of questions from county clerks and others about what are we supposed to do at this organizational meeting? Who chairs it? So it's been a fun discussion over the years, and I think it'll be another fun discussion in February. So with that, Andy, I don't know if you have any closing comments. My apologies, I
Thank
didn't
you.
deliver cake to you during the meeting.
That's all right. We'll get it. We'll figure it out for next month. Um, my closing comment is this. Thank you to everybody who's interested in this because I think that everybody has a desire for good governance, and a lot of people are going through the different iterations of what could happen and trying to figure out what's best. It's not easy, it's not simple, it requires thought, and it's not a sexy topic. It's just not. So thank you for your attention to this, and know that Sarah, WCA are resources that you can utilize because we have the same desire that you do, which is to promote good governance throughout Wisconsin county government. So thank you all for your attention.
All right, thank you everyone for joining us for our January in the boardroom. Again, this recording will be placed on the WCA website. With that, thank you, Andy, once again for a wonderful presentation, and we'll see everybody back on February 25th.